Do you have a duty to obey the law? It depends what kind of duty you're talking about. It follows from the definitions of the terms law and legal duty that everyone has a legal duty to obey the law. If the law requires you to salute the flag, then you have a legal duty to salute the flag. The interesting question is whether you have a moral duty to obey the law. The more general question is what moral reasons, if any, the law gives you. The traditional claim is known as the duty to obey the law, which states that everyone within the jurisdiction of a legal system has a pro tanto moral duty to obey every law of the system, just because it's the law. I'm going to call this claim the duty to obey for short. Let's consider first what it means, and then whether it's true. You're probably wondering what a pro tanto duty is. This is a good question, because the concept of a pro tanto duty, or more generally, a pro tanto reason, is important in this course. A pro tanto reason is a reason that has some weight, but that can be overridden by stronger reasons in cases of conflict. The duty to keep a promise, for example, is a pro tanto duty. Imagine you've promised to attend a concert with a friend on a certain date. But then another friend calls you. She desperately needs a ride to campus to take an exam. You can't keep your promise and also help her, so you have conflicting pro tanto duties. You have to decide which duty has more weight under the circumstances. You have to decide what is your moral duty, all things considered. Pro tanto reasons or duties are also known as prima facie reasons or duties. The readings in this course will often use the prima facie terminology. The duty to obey leaves open the possibility that stronger reasons could override one's duty to obey in the right circumstances, in which case one would not have an all things considered duty to obey the law. The duty to obey states that everyone has a duty to obey every law just because it's the law. You don't get to pick and choose. The fact that obeying the law is inconvenient or burdensome is irrelevant. To some philosophers, the duty to obey seems obviously true, but its truth is hotly contested to this day. Those who accept the duty usually conclude that the state is a legitimate authority. Those who reject the duty usually conclude that the state is not a legitimate authority, a position known as philosophical anarchism. Philosophical anarchism sounds more radical than it is. You might assume that philosophical anarchists spend their time trying to overthrow governments. That's not so. Philosophical anarchism shouldn't be confused with political anarchism, which favors the abolition of the state. Even political anarchists don't necessarily use force against the state. Some political anarchists use violence, but often they just try to persuade their fellow citizens to disband the state by peaceable means. You might also assume that philosophical anarchists go around breaking the law whenever they wish, stealing, provoking fistfights, driving while intoxicated, etc. That's not so either. For one thing, anarchists don't enjoy prison any more than the rest of us do. More surprisingly, an anarchist may decide not to break the law, even if she knows that she won't be caught. A conscientious anarchist won't break a law if she thinks she has an independent moral reason to comply with it. One usually has an independent moral reason not to steal, provoke fistfights, or drive drunk, so one shouldn't do these things, whatever the law says. Philosophers distinguish between complying with the law and obeying the law. Complying with the law just means doing what it requires for whatever reason, whereas obeying the law means complying with it for a special reason, because it's the law. Anarchists never obey the law in this sense, but in reasonably just legal systems, they comply with most laws most of the time. Although philosophical anarchism is less radical than it sounds, many philosophers who understand it perfectly well are still convinced that it's false. They believe that legitimate states are possible. Some of them reject the premise that a legitimate state is one that imposes a moral duty to obey the law, but most of them accept the premise and defend the duty. In the remainder of this lecture, I'll examine two influential arguments for the duty to obey the law, arguments from consent and natural duty. Perhaps the best-known argument for the duty to obey is the argument from consent, or actual contract, associated with the 17th century philosopher Thomas Hobbes. The major premise of the argument is that if someone consents to obey the law, then she acquires a pro tanto moral duty to obey. Consenting can take the form of promising, agreeing, or contracting with the state. Some individuals do, indeed, expressly consent to obey the law. When a foreigner becomes a naturalized citizen, she swears that she'll obey the laws of her new nation. Public officials are often required to take similar oaths. These individuals acquire a consent-based duty to obey, at least on the assumption that they consented freely and had reasonably acceptable alternatives available to them. Critics have long objected, however, that not all citizens expressly consent to obey. In fact, only a small fraction of citizens do so. Most Americans, for example, are natural-born citizens who never take an oath to obey the law. They have legal duties and are subject to sanctions for disobedience long before they reach the age of majority, at which they are legally empowered to execute most contracts. Even in adulthood, most of them are never asked for their consent to obey. Yet the duty to obey applies to everyone within the jurisdiction of the legal system. The classic response to the objection is John Locke's idea that anyone who voluntarily remains within the jurisdiction has tacitly consented to obey its laws. The moral force of tacit consent, however, is not obvious. It's also significant that natural-born citizens are not legally permitted to leave their parents' custody until they reach adulthood, and by that time they've formed extensive attachments to their native land. Emigrating would be extremely burdensome. Can they really be taken to have tacitly consented under these conditions? Instead of basing the duty to obey on consent, or any voluntary act, some philosophers base it on our natural duties, moral duties each of us bears simply in virtue of being a person. A rule utilitarian, for example, holds that everyone has a moral obligation to follow rules that, if widely obeyed, maximize utility. Rule utilitarians who support the duty to obey argue that utility is maximized if everyone follows a rule that requires obeying the law, at least under most conditions. Utilitarianism faces various objections discussed elsewhere in this course. In the past few decades, the natural duty that's drawn the most attention as a basis for political obligation is the duty of fair play. Here's a fair play argument for political obligation. If a group of individuals participates in a rule-based cooperative enterprise, and each member restricts his liberty in ways that produce benefits for everyone, then anyone who benefits from the enterprise owes everyone else a duty to submit to all of its rules as well. Most people within the jurisdiction of a legal system participate in a cooperative enterprise based on legal rules and restrict their liberty in ways that produce benefits for everyone. Therefore, anyone who benefits from their obedience to legal rules owes them a duty to submit to all of the legal rules as well. The first premise is the fair play principle, which captures the idea that benefiting from the efforts of others without contributing one's fair share is free riding and intrinsically wrong. Critics of the fair play argument challenge both the fair play principle and its application to legal systems. A famous objection to the fair play principle originated with the American philosopher Robert Nozick. Imagine a community of 365 residents, most of whom joined together in an agreement to provide daily musical entertainment for the community over the public address system. Every resident, including residents who didn't agree to do so, is assigned 1 day per year to operate the music system. Everyone enjoys the music that plays over the public speakers as they go about their business. But some individuals who didn't agree to participate choose not to contribute when their day arrives. They enjoy the music, but they would prefer not to contribute, even if that meant no music at all. Nozick suggests that such individuals have no duty to contribute, despite having benefited from the system. If we apply Nozick's reasoning to the legal system, we get the conclusion that the fair play principle does not support the duty to obey the law. The assigned reading by John Simmons explores this issue at greater length, challenging the fair play argument.